Hello and welcome to the E-Pathshala course on intellectual property rights. I am Yogesh Pai, Assistant Professor of Law at National Law University, Delhi. Today we are going to discuss a module on biotechnology patents, subject matter exclusions. So let me briefly explain the learning objectives. So we are here to understand how modern biotechnology has helped markets in bringing out innovative products that are very technology intensive, to understand the role of patent in incentivizing biotech inventions and the challenges that biotech technology poses to the patent system, to examine the early origins of patenting biotechnology subject matter in different jurisdictions and in India, to also understand how patent eligibility of biotech subject matter has been discussed and debated during the TRIPS context, and also what was the outcome in the TRIPS negotiations in the form of Article 27, and finally to examine the provisions in the Indian Patents Act 1970 on the question of patentability and patent eligibility of biotech subject matter, specifically in the light of the biotech guidelines issued by the Indian Patent Office in 2013. So first question that we need to ask in the context of modern biotechnology is, what is biotechnology? Any technological application that uses biological systems, living organisms or derivatives thereof to make or modify products or processes for specific use is what has been largely defined as biotechnology, and this is a standard definition that flows from Article 2 of the UN Convention on Biological Diversity. The second important point to note in the context of biotechnology is all DNA is made up of a base consisting of sugar, phosphate and one nitrogen base. There are 4 nitrogen bases: adenine, thymine, guanine and cytosine, and this is popularly called as ATGC. These nitrogen bases are found in pairs with A and T and G and C paired together. The sequence of nitrogen bases can be arranged in many infinite ways, and their structure is known as popularly called as the double helix. It may also be noted that the 4 nitrogen bases are the same for all organisms. Hence, discovery of recombinant DNA technology has changed everything. Recombinant DNA, or what is called as rDNA, involves taking one strand of the DNA and combining it with different strands of DNA to effectuate a desired particular result or a trait. The particular figure explains the difference between biotechnology as a whole and modern biotechnology as a subset. So in biotechnology as a whole, you have natural regeneration, cultivation methods, tissue culture and natural breeding. And in modern biotechnology, you have cell fusion, transfection, transformation, conjugation, agroinfection, and in case of high life forms, you have the GNOs, in vitro manipulated through DNA and RNA. So what are these biotech products ultimately? So modern biotechnology has applications in several areas, including but not limited to medicines, agriculture and industrial purposes, largely to include industrial fermentation, etc. So in case of GMOs, the classic examples of GMOs or genetically modified organisms are Harvard oncomouse, Oxitec mosquitoes. So these are high life forms that have been genetically modified. In case of medicines, you have classic examples like Rituxan, which is produced by Genentech, Humira, which is produced by Abbott, Avastin, which is produced by Genentech again, Herceptin or trastuzumab as it is popularly called, which is a breast cancer drug produced by Genentech, and Epogen produced by Amgen. And there are a host of other products that have been invented in the last few years which are based on biotechnology. So what are the type of claims that are usually made to the Patent Office? The Indian Patent Office has defined or provided a brief description of these guidelines of these such claims in their guidelines in 2013. So they say that the biotechnology applications comprise the claims relating to certain subject matters like polynucleotides or gene sequences, which may either be product or process based claims, polypeptides or protein sequences, again which are product and process based claims, vectors like plasmids, which may be in the form of product or a combination of product and process claims, gene constructs or cassettes in gene libraries, host cells, microorganisms and stem cells, which may again be in the form of product and process claims, transgenic cells, plants and animal tissue culture, pharmaceutical or vaccine composition comprising microorganisms, protein, polynucleotides, which are again in the form of both product and process claims, antibodies or antigen binding fragments thereof, which can be monoclonal antibodies or polyclonal, diagnostic kits and tests, diagnostics tests such as the tests for detection of a mutation in a gene, protein which might be associated with a particular condition such as protein expression or a disease. Now, these diagnostic kits or diagnostic tests can also be in the form of process claims, and as we shall see from cases, these claims have been heavily contested in different jurisdictions, and the Patent Office has made an humble attempt to come out with certain guidelines which provides a framework for biotech applicants in India. So what are the challenges that biotechnology poses to the modern patent system, or how modern biotechnology challenges the traditional patent law? Advance in sciences has now made it possible to isolate and replicate a host of a naturally occurring substance, and thus it raises questions for patent law, and those questions can be like, can it be shown that when viewed as a whole, an application incorporates a discovery that brings about a technical change, and should it be patentable? Second, finding of a new property of a known material or article to be treated as, should it be treated as an unpatentable discovery or should it be patentable? Whether use of such properties to a practical use, may that be patentable or should you need something more? The difficulty of adjudging what forms invention vis-a-vis discovery in biotechnology, specifically in relation to patents on gene sequences or express sequence tags, primarily the arguments are that there is a human intervention criterion. Both discoveries and invention involve human intervention, involve time, labor, skill and investments. How do you distinguish? We thus need to ask the question, what type of human intervention is demanded for making unpatentable discovery and invention? Guidance can be taken from patents that have been granted. It is otherwise too difficult to draw a plain line of difference and arrive at a straitjacket formula. The Indian Patent Office has issued a manual published, and it has also issued the Biotech guidelines, so that may be one of the important ways to find out what is or what is not patentable, especially its distinction between invention and discovery. The Indian Patent Office has said that there is a difference between discovery and invention. A discovery adds to the amount of human knowledge by discussing something already existent which has not been seen before, whereas an invention adds to the human knowledge by creating a new product or a process involving a technical advance as compared to existing knowledge. The emphasis seems to be that there needs to be a new product or a process which represents sufficient technical advance when compared to existing knowledge, and something that is already known before or seen before cannot be patented. So what were the early questions on biotechnology? So one of the earliest decisions in this area which opened floodgates of patent applications in the area of biotechnology was decided by the US Supreme Court in 1980. This is the famous Diamond versus Chakrabarty decision. The question in this case was whether a genetically modified organism produced by the defendant was patentable or not. In this case, Anand Chakrabarty, the scientist, invented a genetically modified organism which was able to break crude oil. So when there were oil spills and if these organisms were released in the wild, this could actually break the crude oil and settle it down. This was a great invention of that point of time, and it went up to the Supreme Court. Justice Berger wrote the decision, and the question before the court was a very narrow one. What is the interpretation that must be given to patentable subject matter as it appears in 35 USC 101, which says, whoever invents or discovers any new and useful purpose, machine, manufacture or composition of matter, or any new and useful improvement thereof, may obtain a patent therefore, subject to the conditions and requirement of this title. So the question was whether a genetically modified organism as invented by Ananda Chakrabarty would fall in either a machine, a manufacture, a composition of matter, or any useful improvement thereof. So the court said, we have been cautioned that we should not read into patent laws limitations and conditions which the legislature has not expressed. In choosing such expansive terms as manufacture, composition of matter, modified the comprehensive with the comprehensive any, the court said Congress plainly contemplated that patent laws should be given wider scope. In fact, the court went on to make a finding that the Congress has intended patent subject matter to include anything under the sun that is made by man. And finally, judged in the light of the respondent's microorganism, it plainly qualifies as a patentable subject matter. That's what the court said. His claim to a non-naturally occurring manufacture or composition of matter is a product of human ingenuity. But there was a huge dissent to this particular case. In dissent, the judges said, the patent laws attempt to reconcile these notions, deep-seated antipathy to monopoly, with the need to encourage progress. Given the complexity and legislative nature of this delicate task, we must be careful to extend patent protection no further than the Congress has provided. In particular, where there was an absence of legislative intention or direction, the court should leave to the Congress the decisions whether and how far to extend the patent privilege into areas where the common understanding has been that patents are not available. The court also went on to record its dissent by stating, first, the Act's evidence Congress's understanding that at least in 1930, that 101 does not include living organisms. If newly developed living organisms, non-naturally occurring, had been patentable under 101, the plants including in the scope of the 1930 Act and the 1970 Act, which provides plant patents, could have been patented without a new legislation. Those plants, like the bacteria involved in this case, were new varieties not naturally occurring. So the dissent seems to stick on what should be the legislative interpretation or the judicial interpretation of the legislative intention from the perspective of patentable subject matter, when the dissent says that these new modern biotechnological inventions was anyway not envisaged, and that was the reason why in 1930s and 70s, when the Congress, the US Congress, sought to extend it to subject matters that were not naturally occurring, they actually extended it through special legislations, and hence the patent law should be narrowly construed. While at the same time, the majority decision goes on with the formula that anyway the Congress has already provided us with the Act, that is section 101 with reference to patentable subject matter, without any restriction with reference to its ability, the ability of the judges to interpret it broadly, because anyway technology changes over a period of time and the biotech industry has grown, and hence to provide certain level of protection to such products, patent law must be expanded to include these. As a result of this decision, post Diamond versus Chakrabarti, the US Patent Office implemented them through the guidelines and started accepting patent applications. But it's important to record one of the older decisions, that is a 1948 decision in Funk Brothers versus Callow in Auckland, where the US Supreme Court in this case held that a trivial implementation of a natural principle or phenomena of nature is not eligible for a patent. In this case, the patentee had discovered that there were strains of each species of root nodule bacteria which do not exert a mutually inhibitive effect on each other. Thus, he was able to provide a mixed culture of ribosea capable of inoculating plants belonging to several groups. The Supreme Court held, and that was a majority opinion as per Justice Douglas, it held that the properties of inhibition or of non-inhibition in the bacteria were the work of nature and therefore not subject to being patented. To quote, It said patents cannot issue for the discovery of phenomena of nature. The court added, the qualities of this bacteria, like heat of the sun, electricity, or the qualities of metals, are part of the storehouse of knowledge of all men. They are manifestations of the laws of nature, free to all men and reserved exclusively to none. He who discovers a hitherto unknown phenomena of nature has no claim to a monopoly in which the law recognizes. If there is to be an invention from such discovery, it must come from the application of the law of nature to a new and useful end. The court seems to have relied on an interpretation that favors a situation where even those properties which were newly discovered by the patent applicant should not be patentable. This position was substantially changed by the decision of Diamond versus Chakrabarti in 1980, post which patents in biotechnology were a common phenomenon. Now, on the other side of the Atlantic, that is in Europe, Europe had to deal with certain challenges, initial challenges. In the Relaxin case, in around 1995, where the invention related to claims concerning DNA sequences of naturally occurring substance that relaxes the uterus of a woman, of a pregnant woman during childbirth, which was obtained from human ovary. Now, in this case, there were a lot of questions that were raised in relation to patentability, both in terms of novelty, inventive step, industrial application, and also subject matter exclusions. Now, the EPO has granted a patent in which the claim 1 of the particular patent application read as follows: a DNA fragment encoding human H2 preproxylin and H2 preproxylin having the amino acid sequence set out in a particular figure that is appended with the patent application. The EPO opposition division upheld the invention and remarked that it was not a discovery by following the EPO guidelines, and it said, substance relaxin has not been previously recognized, although occurring in nature. That a process has been developed to obtain relaxin and DNA which encoded it. That the product were characterized by their chemical structure, and that product has a use. Now, this decision in relaxin actually opened up a lot of issues relating to both ethical and legal dimensions of patent eligibility in Europe. In a subsequent decision pertaining to animal varieties, what animals and animal varieties were excluded by the European Patent Convention was an important question. So the exclusion of plant varieties can be based on a fact that there are different sui generis legislation, but what about animals? In this case, the Howard-Onco mouse decision, Howard-Onco mouse is a genetically modified organism which was already patented in the United States, but the question of whether it would be patentable under Article 53 of the European Patent Convention was a question. Specifically, the exclusion sought to be construed narrowly was under Article 53b, and whether it did bar or not animals in general. Article 53b read, plants or animal varieties are essentially biological processes for the production of plants or animals, and that this provision shall not apply to microbiological processes or products thereof. So the exclusion seems to be pretty much clear that plant or animal varieties are to be excluded and not provided patents. Now the case went on appeal, and finally the conclusion was that there were three versions of European Patent Convention, wherein the use of different wording for animal varieties, varieties, species, races, and that these different classification can lead to certain kind of difficulties in interpretation from a taxonomic perspective. The EPO board bypassed the three variants and said that the claim was for transgenic rodents and not for something that was natural, a taxonomic category higher than species, varieties, and race. It means Article 53b, in case of animal variety exclusion, will only apply when the claim is for a single animal variety. Now, the wording used in Indian context, as we shall see in section 3J in the Indian context, is important because plant and animals in whole or in part, including seeds, varieties, and species, are excluded from the Act. And we shall see what can be the consequences of the application of this decision in the Indian context. What about plants and plant variety? Now, the Europeans have a directive in this regard, and Directive 29, that is the Biotechnology Directive, states, whereas the directive is without prejudice to the exclusion of plant and animal varieties from patentability, whereas on the other hand, inventions which concern plants or animals are patentable provided the application of the invention is not technically confined to a single plant or animal variety. Now, one of the applications, that is Siba Gegi's application, wherein claims direct towards plant propagating material that has been chemically treated so as to make the material resistant to other agricultural chemicals, whether or not these claims were directed to a plant or plant variety. Now, plant breeding introduced a trait into plants that reappeared in subsequent generations. This did not occur with chemical treatment, hence claims are not for plant varieties. That was one of the contentions. Similar reasoning adopted in the plant genetic systems case. Now, Article 1(2) also says that inventions which concern plant or animals shall be patentable if the technical feasibility of the invention is not confined to a particular plant or animal variety. So, there are other provisions that clarify the case laws prior to this directive, and that's the reason why the application was allowed. Now, what are essentially biological processes that are excluded? It applies only to processes and not to products. That is very important because these are related to essentially biological processes. Offsprings of GMOs, that is genetically modified organisms, would be considered as products even if they were produced out of essentially biological process. It means self-replicating seeds, self-replicating plants which produce seeds. Seeds of such plants would be covered by the patent precisely because of the reason that although these are produced out of essentially biological processes, but they were produced through as GMOs. Now, what is essentially biological? Article 1(2) of the directive says a process for the production of plant and animals is essentially biological if it consists entirely of a natural phenomena such as crossing or selection. So, how much of human intervention is needed to make an otherwise biological process non-biological? In this case, there is a very famous test decided in Lubrizol by the European courts. It said, judged on the basis of the essence of the invention, taking into account the totality of human intervention and its impact on the results achieved, we shall try and see whether a process is either essentially biological or not. Now, value judgment is needed. What do you mean by technicality being the criterion, and how that has to be manifested in the invention in relation to an essentially biological process that distinguishes it from an essentially non-biological process is what needs to be looked into. Now, microbiological process can't be excluded, and this is the position in the TRIPS mandate, as we shall see in our next few slides, and also the position in Indian law. In the PGS case, it is the plant genetic systems case, a process in which microorganisms are used to make or modify plants. Here, the process where new microorganisms are developed for specific uses. So, what is a microbiological process? A microbiological process is presumably one that is carried out by microorganisms, but as a microorganism is ill-defined, so too is a microbiological process. What would the word microorganism mean in the context of Indian Act, and we shall try and see that when we discuss the Indian position. No definition, and hence there is still a lot of scope for deciding. There are various possibilities of reading the same. Could it be only restricted to genetically modified organisms or microorganisms? That needs to be seen. So, what was done by the TRIPS agreement? As we can understand, at the time of signing of the TRIPS agreement, and especially during the Uruguay round negotiations, modern biotechnology had already made its dent. So, practically there were new products that were coming into the market. People were investing quite a lot in biotechnology, and hence there was definitely an interest in getting biotechnology subject matter included in the TRIPS agreement. So, Article 27.1 says that any invention, which means all kinds of invention, whether biotechnology or not, should be patent eligible. Any invention, when it involves an inventive step, novelty and industrial application, must be allowed for a patent. And there shall be no discrimination as to the field of technology, which means you can't distinguish saying that this is a patentable subject matter that relates to biotechnology or life patents. Discrimination on the basis of the place of invention, discrimination on the basis of whether it has been locally produced, cannot be made by virtue of Article 27.1, and the only exclusions that are allowed are in Article 27.2 that relates to order, republic and morality, and Article 27.3, especially Article 27.3b, that relates to exclusion of biotechnology subject matter. And it says, I quote, Article 27.3b, members may also exclude from patentability plants and animals other than microorganisms, and especially biological processes for the production of plants and animals or animals, other than non-biological and microbiological processes. However, members shall provide for the protection of plant varieties either by patents or by an effective sui generis system or by any combination thereof. The provisions of this subparagraph shall be reviewed 4 years after the date of entry into force of the WTO agreement. Now, this seems to convey that there was a lot of concern raised by largely those members which were, their opposition to patenting life was largely based on ethical considerations, mainly from the Judeo-Christian tradition, when the church was strongly opposed to any kind of research involving biotechnology. Now, post TRIPS, many countries have implemented the mandate of having biotechnology subject matter application accepted in their patent offices, but certain recent decisions have actually questioned the scope of patentability of subject matter. Now, the first cases in this regard, a recent case, is Association for Molecular Pathology versus Myriad Genetics. This is the US Supreme Court decision in 2013. The question here was whether or not human genes are patentable. Now, human genes have been patentable for long. There were a lot of gene sequences that have been granted patents by the Patent Office for the last 30 years, and now this question is figured in 2013. So in this case, the court said it is important to note that what is not implicated by this decision. First, there are no method claims before this court. That's what the court said. Had Myriad created an innovative method of manipulating genes, which, while searching the particular genes, that is BRCA1 and BRCA2 responsible for breast cancer, it could possibly have sought a method patent. But the process used by Myriad to isolate DNA at the time of Myriad patents were all well understood, which were widely used and fairly uniform insofar as the scientist engaged in the search for a gene would likely have utilized a similar approach. Similarly, this case does not involve patents on new applications of knowledge about BRCA1 and BRCA2 genes. And finally, the court said, as the first party with knowledge of BRCA1 and BRCA2 sequences, Myriad was in an excellent position to claim applications of that knowledge. Many of its unchallenged claims are limited to such application. The court also further on went on to say, nor do we consider the patentability of DNA in which the order of naturally occurring nucleotides has been altered. Scientific alteration of genetic code presents a different inquiry, and we express no opinion about application of Section 101 to this such endeavors. We merely hold that genes and information they encode are not patent eligible under 101 simply because they have been isolated from the surrounding genetic material. Now, there was a concurring opinion which also relates to scientific details, and Justice Scalia wrote, I join the judgment of the court in all of its opinion except para 1a and some portion of the rest of the opinion going on into fine details of molecular biology. I am unable to affirm those details on my own knowledge or my own belief. It suffices for me to affirm, having studied the opinions below and the expert briefs presented here, that the portion of DNA isolated from its natural state sought to be patented is identical to the portion of DNA in its natural state, and the complementary DNA, cDNA, is synthetic creation not normally present in nature. Now, the impact of this decision, or the ratio of decision, seems to be that if your claims are directed towards the gene sequences that are present already in nature, and what you do by simply isolation and purification and identifying the particular gene sequence, that will not entitle you for a patent. But having said that, if you come out with certain genetic sequences through cDNA, that is synthetic creation, these can definitely be patented. Now there are some critiques of this decision, but other critics have pointed out primarily that such a decision may have impact on biotechnology industry, but some others believe that the time for this decision is already over, because a lot of these early patents that were granted were in 1990s, and that this decision may not be so relevant in the context of the second half of the second decade of the 21st century. The second case that is important in the context of diagnostics is Mayo versus Prometheus. This decision is decided by the US Supreme Court in 2012. Here the claims were directed to a method of giving a drug to a patient. Now what happens is, you need to know what is the right dosage that a patient has to be given. So here the invention was relating to measuring metabolites of that drug, and with a known threshold for efficacy in mind, deciding whether to increase or decrease the dosage of the drug. Now in this case the court said the correlation between naturally produced metabolites and therapeutic efficacy and toxicity to be an unpatentable natural law, and it also found that the first two steps not to be not genuine applications of these laws, but rather drafting efforts designed to monopolize the correlations. Now the court was saying that because these methods for making such determinations were well known in art, that is in prior art, and this step simply tells the doctors to engage in a well understood routine conventional activity previously engaged by certain scientists in the field, such activity is naturally not sufficient to transform an unpatentable law of nature, and the court seems to think that such correlation is a kind of unpatentable law of nature, and so it is saying that such unpatentable law of nature you cannot translate into a patentable subject matter application of such law. And the conclusion is that 1. A newly discovered law of nature is itself unacceptable, unpatentable. Second, the application of the newly discovered law is also normally unpatentable if the application merely relies upon elements already known in the art. Now, of course, there were questions relating to impact of this decision on the industry. The court also took it head on and said, in consequence, we must hesitate before departing from established general legal rules, lest a new protective rule that seems to suit the needs of one field produce unforeseen results in another. And we must recognize the role of the Congress in crafting more finely tailored rules where necessary. We need not determine here whether, from a policy perspective, increased protection for discoveries or diagnostics laws of nature is desirable. So that question, they said they would leave it to the Congress to decide, so that they could come out with more finer rules relating to patent law that allows such diagnostics to be patented. Now, what is the position in India? If you look into the historical position, Section 5(1) was interpreted, that is prior to amendments, to mean that some substances like microorganisms were capable of being used in medicines, food, and they could be produced by chemical processes, biotechnology, biochemical, microbiological, and these would be excluded from the definition of 5(1). And 2002 amendments, you can check, added an explanation for the clarification. But the 2005 amendments repealed Section 5 completely to bring in line with the mandate of the TRIPS agreement. Now, what does it then say? One of the early decisions, and this was prior to the 2005 amendments, is the Dimminaco AG versus control of patents. In this case, the invention was relating to an investigation related to process for preparation of infectious bursitis vaccine. Now, the question is whether it's a useful. The invention is actually useful for protecting poultry against contagious bursitis and contains a living virus, as in case of any other vaccine. Now, since this vaccine contained a living virus, the patent office seemed to have rejected the application. It went on in appeal to the Calcutta High Court, and the decision of the High Court is very interesting. The court propounded something called as a vendibility test. It said that if a product was vendible, it should not matter whether it is a live subject matter or not. Now, and it rejected on grounds of section 21J, as it then was. It said administrative policies and wordings in the Act must be differentiated. You should look actually into the wordings of the Act. No case of granting patents on living matter except lopsiding, drying of materials in the frozen state. Meaning given to the word manufacture was discussed. However, the process patents allowed as under section 5 are not excluded. Now, post this decision, there was a lot of discussion, and then finally you had the 2005 amendments. Now, the thumb rule is that all inventions pertaining to living subject matter except as ruled out by section 3 are patentable, which means Indian law does not discriminate between biotechnology and non-biotechnology subject matter. All kinds of subject matter are routinely accepted by the patent office, but there are certain exclusions. We'll discuss few of them in this particular module. Section 3B allows exclusion based on public order, morality, and which causes serious prejudice. Now, the test for public order or morality, or which causes serious prejudice to plant, animal life or human life, is not primarily relating to the invention being per se immoral, but the test is based on the commercial exploitation of such invention. So only based on the commercial exploitation, it means there must be some kind of external law to prohibit such a product as contrary to public order, morality or causing serious prejudice, and then definitely there is a strong ground for the patent office to reject such patents under section 3B. Section 3B derives its strength from article 27.2 of the TRIPS agreement, which allows for such exclusions. So WTO member countries are free to allow such exclusions. Section 3C is a very interesting provision which primarily makes the distinction between invention and discovery, which says that mere discoveries of any living thing or non-living substance occurring in nature is not patentable. Now, everything is fixated around the word mere, and how do you interpret mere discovery vis-a-vis kinds of discoveries we have in biotechnology subject matter, wherein genes are routinely isolated and purified, and subsequently the express sequence tags are patented through various types of claims. There are express policy considerations that are employed in section 3J, wherein the exclusion extends to plants and animals in whole or in part. It also excludes seeds, varieties and species, essentially biological processes for the production and propagation of plants and animals, but as per the mandate of the TRIPS agreement, wherein microorganisms must be patented, here also in India microorganisms are allowed patents. Now, the scope of microorganisms is highly contentious, whether it includes certain kind of genetically modified organisms, and to what extent does it extend to higher life forms. Secondly, whether it could also include viruses, whether they are living, non-living. How do we actually interpret the term microorganisms is highly contentious. The fourth kind of exclusion relates to methods of treatment exception, whereas diagnostic, therapeutic, surgical methods that are used for treatment of humans are excluded. Now, section 3P is another exclusion, that is the fifth final one, wherein traditional knowledge or an invention that is essentially based on traditional knowledge is excluded. So these exclusions have huge implications on biotechnology subject matter. Now, we have the Biotech guidelines issued by the Indian Patent Office. You can refer to your module wherein the exclusions and their possible meaning have been discussed in detail. One of the important things that need to be understood in the context of TK associated with genetic resources is, because of our experience in neem and turmeric patents, we thought it would be a defensive strategy to prevent biopiracy, or call it bioprospecting, by having section 3P. And based on section 10 requirements, you now have the disclosure of biological source and origin of the particular biological material, wherein such material has to be deposited with the repository, wherein without such disclosure, the patent application is, or the grant of the patent is liable to be revoked. Section 10.4 deals with sufficiency of disclosure and the best mode of performing the invention, and section 5 deals with 10.5 deals with the unity of invention and the support of the claims, which are all relating to how you claim biotechnology subject matter. it will be important to revisit the Biotech guidelines of the Indian Patent Office along with the Manual of Patent Practice and Procedure and also the TK guidelines that are issued by the Indian Patent Office to understand the nature of what is excluded and what is included. There are very fine illustrative examples given in those guidelines which can be used by patent applicants to narrate their subject matter and the type of claims that they can make and gain patents for. In summary, modern biotechnology has definitely helped markets to bring innovative products that are highly technology intensive. The role of biotechnology in bringing out these new products in the form of medicines, agricultural biotechnology has immensely helped the markets and the society towards gaining from the fruits of this modern technology. Second, the role of patent in incentivizing biotechnology is important, and there are certain challenges that the patent system has itself produced to biotechnology and vice versa. The early origins of patenting biotechnology subject matter from a comparative jurisdictional perspective and in India has been thoroughly discussed in this module. The patent eligibility of the biotechnology subject matter through various sections, through various provisions in the context of the TRIPS agreement has been elaborately discussed in this particular module. And finally, we have also discussed in the context of Indian Patents Act 1970 several provisions relating to both patent eligibility and patentability of biotechnology, specifically in the light of the guidelines issued by the Intellectual Property Office in 2013. Thank you very much.